August 31, 2012 is Justice Done Dirt Cheap. Just want to talk about share some thoughts about the judiciary as the judges who make up what we call the judiciary. Now what's interesting is judges who are an oath of office, where they're supposed to act without fear or favor, treat everyone equally, protect the Charter of Rights and Freedoms, protect people's rights, and not make rulings that are unfair. So far I've had many experiences, most of my experiences have been unfair, unbalanced, prejudicial rulings, and it's just hard to believe that it's mistake after mistake after mistake. There seems to be an actual theme to what's occurring. Now, as an example, like one case, I filed a motion to have the court order costs against a party who was evading service, who was causing me a lot of difficulties, and I looked up the rules of court, found out all the case law supports it, provided affidavits from several people, several witnesses who witnessed this particular defendant, which is Trina Rodgers, who was evading service and being difficult of service to the point of being dangerous, where every time I attempted to serve documents, she would call the Fredericton police force, who would arrive shortly thereafter, for a simple matter of me serving documents. She knew what I was doing because I announced it. I announced who I was, what I was doing, why I was there. I asked her to receive the documents, and then I would leave the documents outside her house, but with her, so she knew they were there. Now what's amazing is, even though I did everything with respect, integrity, open, announcing everything I was doing, announcing who I was, so there's no question about what was happening, she still went ahead and called the Fredericton police force, which they arrived several times. And if I hadn't basically left quick enough, I would have been arrested again, which is the theme that's been occurring in my life for the last 6 years. She calls the police arrive, I'm not out of the way quick enough, they arrest me, batter, assault me, drag me down to the police station, then release me without charge. There's nothing to charge me with because I'm not doing anything wrong. Now, so I filed a motion, had a hearing, I prepared a very comprehensive brief regarding the matter of costs for a party who is evading service. The judge refused to accept my brief, refused to accept my argument, interrupted me when I tried to speak, would not let me speak, sent the sheriff over to sit next to me to basically keep me in line, when all I was trying to do was be heard. It's a hearing. I filed the motion. I wanted to be heard. She wouldn't let me be heard. Now what's amazing is that I filed several affidavits that supported my position by 3 different witnesses who saw these behaviors that are considered evasion of service, which entitled me to costs to show this defendant is being unduly difficult. And I prepared a comprehensive brief which the judge refused to accept, and the judge refused to hear me in argument at the hearing. Now in response to that, Trina Rodgers filed an affidavit that was almost as thick as a phone book, a Fredericton phone book anyway, which had all kinds of material that had nothing to do with the motion. There's copies of affidavits from other actions, other motions, copies of printouts from websites that had nothing to do with the motion before the court. So the exhibits that made up the affidavit were irrelevant to the motion. Not only that, but the affidavit actually contained statements which supported my position, where in the affidavit she admitted to not answering the door when I announced I was process serving documents. She admitted to calling the Fredericton police force. She admitted to all these things that formed the basis for my position, which is why I filed the motion in the first place to have cost ordered against her, to reprimand her for this bad behavior. So hopefully she would discontinue that bad behavior and we could move along copacetically in the future. Now, one of the things that was very interesting at that was included as part of my evidence was I provided a statement, an affidavit that was from someone from the Canada Post depot who actually witnessed Trina Rodgers engaged in actively reading a document, or reading the envelope of a document to find out where it was coming from. When she saw that it was coming from me and it was court documents, she refused to accept it. Now, the judge actually commented that she refused to accept that hearsay evidence. And what's amazing is that after that, I actually had a testimony by that particular Canada Post worker who said clearly what occurred, just as it was provided in the affidavit, in the first person perspective, yet the court refused to accept that statement. It's just unbelievable. So in that motion, all the evidence was in my favor. I provided a comprehensive written argument that should have been considered, which took a lot of time and effort and research and preparation. The responding party, the defendant, provided no written submissions, barely said anything to the judge at the hearing, and the stuff that was said, the statements that were made, were irrelevant to the actual motion before the court. Her affidavit in support of her motion was a single affidavit, was full, 99% irrelevant material, and the 1% of relevant material actually supported my legal position and should have been used as part of evidence in my favor. Now, despite all this, despite all of those things I just explained to you, the judge actually ordered against me, ordered $500 in cost to be awarded to the defendant. Now, $500 for what? She didn't actually prepare any written submissions, did no research on a legal position, had no prepared statement, provided affidavit material that was irrelevant, superfluous. Yet the court awarded $500 in her favor. It doesn't make any sense. It's illogical. It goes against established principles of awarding costs. Now, what ended up happening after that decision was rendered, I filed for leave to appeal, which is the normal process to do in New Brunswick. In Brunswick Court of Appeal, I filed leave to appeal because this decision is wrong. It should not be upheld, should be overturned, and the costs should be reversed. So that I'm awarded $500 cost to reprimand her for bad behavior. Now, when I went for leave to appeal, the judge acting as the leave to appeal judge did not grant leave to appeal and said basically that it was a discretionary decision of the judge, and that court saw no reason for overturning the decision. That's a second decision up the line that doesn't hold up to basic legal principles, does not hold up to our understanding of the courts, how the courts work, how judges are supposed to judge, the way evidence is presented or considered, the weight of evidence. It just goes against everything that people are told the courts operate like. Now, I did not file for leave to appeal to the Supreme Court of Canada in that instance, because it's a long, arduous process filing an appeal to the Supreme Court of Canada. The Supreme Court of Canada gets on average 90 applications per year, and they only accept 80 of them. So this matter had about a 0% chance of being accepted by the Supreme Court of Canada when they take only 10% of applications. And those 10% tend to be people who are facing a lifetime in jail unless their appeal comes through, or very serious civil rights matters and things of that nature. So based on what I've experienced so far at the Supreme Court of Canada, I filed 2 other applications at the Supreme Court of Canada on 2 different matters that both had a lot of merit. They should have been heard, they should have been decided, and they should have been decided in my favor. But both applications were rejected because, like I said, only 80 out of 900 a year actually make it. So I didn't go forward and file an application to the Supreme Court of Canada in that matter. So I'd like to say this is a unique experience where it's one bad judgment after another, but unfortunately it's not. It's continuing on with the theme that I've experienced for the last 3 years in Court of Queen's Bench, New Brunswick, and to the various courts in New Brunswick, all the way up to Court of Appeal on several occasions. So I just wanted to give that assessment and some information regarding court process, court procedure, an example of how I see that the courts are not working as we've been told that they're supposed to operate like. Thank you for listening. This is Justice Done Dirt Cheap, Fredericton, New Brunswick, Canada. Have a great day.